here's a quiz. Ramlalla Virajman, Tirthankar Lord Rishabh, Bhagwan Shri Sankatmochan Mahadev Virajman. What is common between all three of them? Well, all of these deities have been involved in legal suits against masjid or dargah properties across the country, and in this video, I, Apoorva Mandhani, will tell you how deities are able to fight out these legal battles. But before I begin, I have a small appeal to make to all of you. This is to get a paid subscription of ThePrint, because here at ThePrint, we believe in non-hyphenated, fair and questioning journalism, and for this, we need your support. So to encourage us, to support us, I'd urge all of you to consider taking a paid subscription. The procedure for the subscription is what you can see on your screens right now. Even the links for taking the subscription, for the host of benefits that these subscriptions get you, all of that is available in the description of this video, so do check it out. Now, getting back to the video. Now, in India, a deity is considered a juristic person or a legal entity that can own property and sue like a living person, while God, which is an abstract and omnipresent concept, hasn't been given a juristic identity. There's a distinction there. Deities in Hindu law have been conferred personhood. Now, one of the most high-profile cases involving a deity, of course, was the Ayodhya dispute, where Ramlalla Virajman, represented by his next friend, who was the late Devki Nandan Agarwal, who was a former judge of the Allahabad High Court, was one of the key parties. Ramlalla Virajman, the deity, was one of the key parties. In February 2008, Vishwa Hindu Parishad leader Trilokinath Pandey took Agarwal's place as the next friend, and then a 5-judge Supreme Court bench declared Ramlalla a juristic person in a November 2019 judgment in the Ram Janmabhoomi Babri Masjid title dispute case. Now, most recently, a suit was filed by Bhagwan Shri Sankatmochan Mahadev Virajman through his next friend and devotee Vishnu Gupta, claiming that a shivling was beneath Ajmer's dargah of Sufi saint Moinuddin Chishti. But how did the concept of assigning the status of a legal person to deities begin, and what legal rights do these judicial persons have? Let me start from the beginning. Now, several Indian and English judges have looked at the legal characteristics of Hindu idols and the properties associated with them in many judgments in the past. So this is not a new concept. In fact, before independence, several such questions came up before the courts, with English judges applying Hindu law to religious endowments. So the concept of conferring legal personhood on Hindu idols was evolved by courts to ensure that the law adequately protected the properties endowed for religious purposes. In the Ayodhya judgment, the Supreme Court explained that English judges began recognizing the legal personality of Hindu idols due to two issues that were facing Indian courts back then. One was the risk of maladministration by shibates or managers, where land is endowed for religious worship, typically for an idol, and two, the threat of devotees being denied access to land designated for public worship. But this concept and this principle isn't limited to just Hindu deities. In fact, the Supreme Court has even held in 2000 that the Guru Granth Sahib is a juristic person. So since Sikhism doesn't believe in idol worship, the court extended the same principle to the Guru Granth Sahib, noting that according to the tenets of Sikhism, it is the Guru. So the Guru Granth Sahib was therefore held to have juristic personality, and it was ruled that property can vest in it. But granting legal personality to a Hindu idol does not mean conferring legal personality on divinity or the supreme being. This is a little complicated, so let me explain. Essentially, the Supreme Court had explained that the supreme being is omnipresent and divinity is universal and infinite. It's present everywhere. Therefore, divinity cannot be granted the status of a legal entity because it would not be possible to form its contours or boundaries. So it would be impossible to distinguish where one legal entity ends and the next begins. But Hinduism provides physical manifestations of the supreme being through idols, which serve as identifiable forms of worship, making them eligible for legal recognition. So that's a tiny distinction between that. So the court has essentially explained that Hindus may create endowments for religious purposes, and there is public interest in protecting the pious purpose for which these properties were endowed. But of course, an idol cannot enjoy the possession of the property as a natural person would, even though an idol can own property. Therefore, the idol needs a human or a shibet to manage its properties, arrange for the performance of ceremonies associated with worship, and take steps to protect the endowment by bringing lawsuits on behalf of the idol. Ideally, only the Shibaite can bring a suit on behalf of the deity. However, the Supreme Court clarified way back in 1966 that in cases where the Shibaite is negligent or is guilty party against whom the deity needs relief, worshippers or other interested parties in the religious endowment can file suits to protect trust properties. And this is how several suits have been filed on behalf of deities, laying claim to mosque or dargah properties across the country. For instance, the original suit in the Gyanvapi case was filed way back in 1991 by devotees of the deity Swayambhu Lord Vishweshwar, who claimed that the mosque in Varanasi was built at the site after a temple was demolished in 1669 on the orders of Mughal Emperor Aurangzeb. Therefore, they demanded that they should be allowed to renovate and reconstruct their temple. This suit remained pending for years because of an Allahabad High Court stay in August 1998. However, in December last year, the High Court ruled that this suit was not barred by the Places of Worship Act 1991. The case is currently being heard by the Varanasi Civil Judges Court. In another case in 2020, a suit was filed on behalf of the Jain deity, Tirthankar Lord Rishabh and Hindu deity Lord Vishnu through their next of friends against the Quwwat al-Islam Masjid in New Delhi's Qutub Minar complex. The suit claimed that the mosque was built in place of a temple complex. Now, a Delhi civil court rejected the suit in December 2021, but an appeal against this decision is pending before an additional district judge in Delhi. And in the latest such example is the Ajmer Sharif case. In this, the suit claimed that a shivling lies beneath the underground passage to the cellar within the complex of the dargah of Sufi Saint Moinuddin Chishti in Ajmer. The suit has been filed by Bhagwan Shri Sankatmochan Mahadev Virajman through his next friend and devotee Vishnu Gupta, who is the national president of Hindu Sena. In the suit filed in a civil court in Ajmer earlier this year, Gupta has demanded that the deity, which is Bhagwan Shri Sankatmochan Mahadev Virajman, should be declared the owner of the property where Khwaja Dargah Sahib is located in Ajmer. And this is how these deities, all of these deities, have been sort of engaged in legal battles and are fighting out these cases in various courts across the country. That's all I have for you today. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.